There was a time when discussions between bride and groom about their respective financial assets before marriage was, well, just not the done thing. And it remains difficult to protect assets when separating. Eric Tansley went through a long and difficult 3-year divorce.
I'd inherited a considerable sum of money from my father a few years ago and endeavoured to have that protected, but there proved to be no way of doing so, and so it's just in the pot and it's been dissipated.
Under the current law, couples can make pre- and post-nuptial agreements, setting out how their assets are to be split on divorce or on the dissolution of a civil partnership. The courts may follow these agreements, but they're not binding, so couples can't be certain that they'll be upheld. Well, now, the Law Commission wants that to change.
We're recommending the introduction of a new form of agreement called the Qualifying Nuptial Agreement, which will enable couples to make enforceable agreements about the way that they share their property on divorce or the dissolution of civil partnership.
To be binding marital agreements, both partners must have had legal advice, disclosed all relevant information about their finances, and the agreement must be made at least 28 days before the wedding or civil partnership. Critically, the agreements would allow people to ring-fence money and assets. It's anticipated they'd be particularly popular with those entering second marriages who want to protect property for their children. The government will now consider the Law Commission's recommendations that they become binding. Clive Coleman, BBC News.